Thank you, Mr. Speaker, and good day to all. I extend a special welcome to the representatives of Scanaipo and to extend best wishes to you for the recent milestone anniversary that you celebrated, and wish you every continued success as you progress and you grow as young parliamentarians who can one day aspire to lead this country and this parliament. Mr. Speaker, I rise with your leave to move the motion for the second reading of the Bureau of Standards Bill 2021, which would have had its first reading on Thursday, August 5th, 2021 in this Honourable House. In rising, I would also wish to open the debate on the said bill, which I consider timely. But before I get into it, I am careful to note that this government has ensured that given the nature of the bill, we would have offered the general public and all stakeholders concerned a period of 90 days in which to review the bill, because as part of our democratic process, once a bill has had its second reading, it is in the public domain, and interested persons are free to register and document their concerns on the said bill. On that note, I should indicate that up until this very morning, we would not have received any negative feedback on the draft recommendations put forward in the bill. We would have also engaged in a consultation with stakeholders to go an extra step as recent as last Friday, November 5th, in a session for at least 2.5 hours with the support of legal counsel from the Attorney General's chambers to go through the provisions of the bill and to ensure that we provide an opportunity for questions to be asked and answered and clarifications given. I wish to indicate, Mr. Speaker, that the bill that is before us is actually meant to do two things. One, it is intended to replace an existing piece of legislation that would have been passed in 1999 as the National Bureau of Standards Act, Chapter 23.15, Act Number 7 of 1999. And the second purpose is to update our national legislation in terms of providing for the development and policing of a national standards and quality infrastructure in St. Kitts and Nevis, so that our people, the consumers of this federation, importers, wholesalers, retailers alike, can have the best quality when it comes to goods and services, practices and processes for which they will have to pay in order to enjoy the luxuries of same. When the existing legislation would have been passed in 1999, which is like some 22 years ago, because if my memory is correct, I would have been, in a previous life, fortunate to have been part of the consultative process when that bill would have been presented to the former government based on the support offered by CROSQ, the Caribbean Regional Organizations for Standards and Quality, based in Barbados. And it was deemed necessary to take St. Kitts and Nevis beyond the archaic system of having a bureau, even though it was not called that, which mainly looked after interests such as perhaps the examinations of weights and measures. Many of us recall having small shops around the islands where you have your scales, and once a year, twice a year, representatives from trade would come around and ensure that when you sell somebody something that has in a pound of rice, they're checking that scale to make sure that you're not dipping the scale when you're at maybe 3/4 of a pound, and so forth. So in 1999, when this legislation was passed, it saw fit to create the Bureau of Standards then, and put in motion a system whereby you could at least have basic standards when it came to the sale of goods and services, etc., and also basic food quality standards at that time. That legislation, which was comprised of some 6 parts, 47 sections, and 22 definitions under the interpretation heading, would have provided, insofar as the Bureau is concerned, for staffing, financing, operational matters, the preparation, promotion, and control of standards, both mandatory and voluntary. When the existing legislation of 1999 would have been passed, we were still operating under the 1974 CARICOM Treaty of Chagua-Ramos, even though negotiations would have already commenced even back then for the RNM in terms of looking towards a future that is more secure for the people of the CARICOM member states, that would enable better services, better quality goods, etc., to be part, and better trading arrangements to be part of the revised bill. This new bill, therefore, as was the case with the original one, is meant to be what is considered an omnibus piece of legislation, meaning that it is intended to be applied across the member states of CARICOM in a manner that facilitates the goals and the ambitions, particularly of the CARICOM single market and economy. And by that token, to focus on the goals and ambitions of aiding the process of the free movement of goods, services, capital, and labor across the member states. And of course, the revised treaty would have eventually been signed in the Bahamas in July of 2001. The bill before us, Mr. Speaker, therefore goes a lot further in terms of where the existing legislation would have finished off, while preserving those elements in that same legislation that are still relevant. Because even though we are seeking to repeal that act of 1999, there are still germane portions of it that it would be wise to carry forward. The bill calls for the application of quality-based international standards for goods and services coming into the country, and it also covers the applications of practices and processes across multiple sectors and disciplines. In other words, you could have a standard being developed for manufacturing, for a medical procedure, for a way a good might be processed after coming out of the field before it comes into the hand of a greengrocer or somebody with a sidewalk vending outfit, or even before it gets into the supermarket. You can have a standard for virtually anything. And basically, given that St. Kitts and Nevis is a long-standing member of the WTO, the World Trade Organization, it should not be surprising that one of the reasons that we would want to have the legislation updated is to ensure that the national quality and standards infrastructure is in place in the country, so that in the event there are issues of trade disputes, especially those that go across borders, that we will be in a position to make our case clearly. As a side note, we are also very grateful that the WTO has moved out of a period of abeyance and inactivity and questionable relevance now that it has secured a new director general, and at the same time, it then means that the dispute settlement mechanism provided in the WTO has now been put back on an even footing, given the fact that the former Trump White House would have stymied the process in terms of the withholding of approvals for certain key members of that dispute settlement body. But however, the new administration in Washington has made it possible for us all internationally to move on and redeposit our confidence in the dispute settlement mechanism provided by the WTO. While we are a small member state, I should note, Mr. Speaker, we do not get excuses for being small. And even though the burdens of being a member of the international community are great, there are burdens that we have to pay the cost of if we intend to be a responsible player in the international trading community. A close look at the Bureau of Standards bill before us would also show us, Mr. Speaker, that there are noticeable differences from the existing act that is still in force. Before I point out these features, however, I think it will be useful for us to have a basic understanding of what we mean when we talk about standards. And it's in its most basic form, a standard could be defined as an agreed manner in which something has to be done, such as a manufacturing process, how service, especially customer service, should be executed, how customers should be treated, how a medical procedure should be conducted in a surgical theater, what happens first, etc., what instruments to use, and so forth. How a test or an examination should be conducted. For example, in our context, the CSEC examinations, how is that set up? What measures do we put in place to make sure that there's no cheating, that it's a fair examination, etc.? Yet, in spite of the voluntary nature of standards in general, there are huge benefits that can be accrued if we take the deliberate step to make sure that we put them in place, including but not limited to preservation of human health and life, environmental protection and management, the approval of processes that impact on food safety, the execution of managerial and organizational efficiencies, manufacturing of appliances and spare parts to ensure conformity, and the list goes on. And to just give us a basic example, to ensure that when somebody says they're manufacturing AA batteries, which we refer to locally as penlight batteries, that regardless of the supermarket, the grocery store, the hardware store that you go into, there are certain basic features that a penlight battery should have, which you expect it to have, if it is to do what it is supposed to do in the appliance that it should power. So that's a very basic understanding of what we mean by conformity to standards. Mr. Speaker, the bill before us, therefore, is comprised of some 9 parts, 53 sections, and 32 definitions under the interpretation heading. And as such, the bill covers the following sections: functions of the Bureau, administration of the Bureau, licenses for use of the standards mark, business of the Bureau, quality certification, offenses and penalties, appeals, and miscellaneous provisions. Upon close examination, what we would recognize if we were able to compare and contrast the existing legislation with the draft bill that is in front of us is that the areas where we are noting new and or expanded features in the bill are as follows. On the licenses, which will be granted by the Bureau in order to use the St. Kitts and Nevis standard mark. In other words, the Bureau will have the authority to determine if a particular importer, retailer, etc., or manufacturer has the right to sell or trade in a good by license once an established criteria has been set up. The other new or improved feature is the quality certification by the Bureau to certify standards and quality and also conformity to the agreed standards. For example, the Bureau will be in a position to certify even before goods leave the warehouse that these goods meet certain certification standards. And some of these goods in particular that would warrant that type of certification would include white goods, goods that would, like washing machines, refrigerators, other electrical appliances that you need to plug into an electrical outlet to make sure with all safety and all confidence that when you pay your good money to buy these items and you take them home and you plug them in, you're not going to have an explosion that takes off your roof or that you would not be electrocuted. So that is what we're talking about here. Offenses and penalties. Now, this is a section that has been greatly improved, and I will come to that later in my discourse. But it is put in place in order to prevent fraud, counterfeiting, knockoffs, and basically to protect consumers and importers and the public in general in terms of product tampering, false advertising, false labeling, and so forth, so that we will know ahead of time that every secure measure, every security feature is being put in place to ensure that when consumers, when the public, when importers, wholesalers buy goods from overseas, we can basically close our eyes and assume that it is a good quality product, even if you have to pay more for it. And of course, that will prevent us from falling victim to some of the woes and transgressions of business. For example, you walk into a store up at 4th Street and you see a handbag marked Fendi, and they tell you you can get it for $50. And anybody in their right mind knows that there's no way in God's green earth that you're going to get a Fendi bag for $50 unless it was manufactured in some questionable outfit, maybe in a third world country, or it fell off the back of a truck. and somehow you're foolish enough to buy it, when any sensible person recognizes that a Fendi bag could cost you $2,000, $3,000 US. Ladies in here, I'm sure some of you know exactly what I'm talking about. There's an appeals process that has been placed into the new draft bill, which was not present in the existing legislation. And this has been deliberately put in place to ensure that individuals, organizations, manufacturers, retailers, wholesalers, importers, etc., will have an impartial and graduated avenue through which they could have a hearing and a determination of matters for which there might be disagreement in terms of decisions that are taken by the Bureau. So that if there comes to a point where there is a dispute, a trade dispute of any type, at least we could have a graduated process where it can go to several steps before having to jump to the final recourse, which is the High Court to address a grievance. So that process has been put in place. Mr. Speaker, in terms of these new and improved sections in the new bill, it would be remiss of me if I did not make the effort to point out that in terms of the list of offenses and penalties, there has been a significant expansion, and that the penalties are far more severe, basically sending the message to the public, to wholesalers, importers, retailers, that anything that you sell to the public, we are going to hold your feet to the fire, and that you will not be allowed to take advantage of persons who spend their hard-earned money on goods and services and figure that you can get away with it, and they have no choice but to take what you dish out to them. So, for example, these penalties and offenses are outlined in Part 6 of the bill, in particular, Sections 33 to 43, and pertain to non-conformity to and in compliance with any established technical regulation in terms of goods and services, processes, and practices as it relates to the sale of the said goods, services, processes, practices, unlawful use of labels. So for example, you cannot decide to bottle your own water here in St. Kitts and Nevis and use your computer, use your printer to put on a label that says Evian, when we know that Evian might be the global Rolls-Royce brand when it comes to spring water out of France, but you're trying to knock it off here in St. Kitts and Nevis. False representation in terms of statements and claims regarding the use of the standard mark. For example, if your product, when submitted to the Bureau of Standards, does not cut the mustard, and you try to fake it, to counterfeit the standard mark, and it is discovered, then there is a penalty for that. Unlawful obliteration or a stamp or a standard. For example, there might be something missing from your good, maybe an expiry date, which is a key feature in terms of standards when it comes to food labeling, and the date might have passed, but you're smarter than everybody else as a retailer, so you take a black mark, a Sharpie pen, and you scratch out the point where the listed expiry date and manufacturing date appears, because you want to get it off your shelf, and that too is illegal. The attempt to defraud. For example, I gave some instances of knockoffs, counterfeiting of merchandise, etc. Same would go for people buying designer shoes, and you figure there's some store that is open up down at Port Zante that you can get a pair of signature, red bottom, stiletto, Louis Vuitton shoes, and you could get them for 100 EC, and that would be foolish, because internationally the best price you might get for a pair of that type of shoe might be $3,000 US, and so forth. Unlawful use of the standards mark. For example, if you walk into the Bureau of Standards, where Mr. Laplace, and thank you for joining us here, we do have our Director of the Bureau of Standards here, Mr. Stuart Laplace, and it is largely through his efforts we have gotten this far in terms of the advancements and the widening and scope of services at the Bureau. If you break into the Bureau and you decide, well, somebody has told you where you could find a standard mark, and you're going to use them to put on your products, there will be hell to pay for that too. Impersonation of the inspectors of the Bureau. The legislation calls for inspectors, as is the existing legislation, and you will not be allowed to counterfeit that by claiming to be a representative from the Bureau so that you can simply gain access to a place of business, a warehouse, a manufacturing process, etc., because perhaps maybe you are competing interests and you would like to know what their trade secrets are, so you're going to try to impersonate an inspector. That will not be allowed. Tampering with articles that may have been seized by the Bureau's inspectors. The legislation allows for seizure of some of these articles if upon inspection they might be needed as evidence in a court of law. Mr. Speaker, for all of these 9 offenses that I would have just outlined, convicted persons would be liable to a fine of $10,000. In the case of a continuing offense, there is an additional penalty of $1,000 per day for every day that the offense is continued, or imprisonment of 2 years. I should point out that the existing legislation contains much lower fines. For example, fines cannot exceed $5,000, and there can be a term of imprisonment of not more than 2 years or both. In the case of continuing offenses, there's a penalty of just $100 per day following the existing legislation. And as I noted earlier, the new bill is seeking to take that up several times more by putting that continuing offense penalty at $1,000 per day. I should indicate, Mr. Speaker, that in addition to these stiffer penalties and fines, the bill before us also provides for the imposition of an additional penalty, in particular, the assessment of the monetary value that you would have gained or would have been likely to gain by the committing of fraud when it comes to the sale of goods and services that may not meet the mustard when it comes to standards and quality. What this means, moreover, is that a term of imprisonment of 12 months can be imposed if the offender refuses to pay for that. So it can be assessed based on how much money you made unlawfully, and for the time that you continue and refuse to pay the penalty, there could be a separate imprisonment of 12 months. And I would also state that the offenders are also liable to suffer forfeiture of any articles pertinent to the offense that is committed by order of the High Court. One might ask, why is the government going to all of this trouble to impose far stiffer penalties in this new Bureau of Standards Act? And the answer is simple. The simple answer is that this government has made it clear that the top priority for us is our people, and by extension, our people deserve to have nothing less than the best when it comes to the sale, purchase, and consumption of goods and services. We also deserve the best when it comes to standards that relate to processes and practices. In other words, as a member state of the WTO and as a proactive member of the international trading system, our people should not be forced to accept substandard goods that are shipped from the US, from Europe, or from wherever. And it should not be taken for granted that we are obligated to pay for them and to take them. It should never be taken for granted to anybody in the international community that because St. Kitts and Nevis is a small jurisdiction, that anything you wish to dump on the region and by extension on St. Kitts and Nevis, we have no choice but to take it. Because those of you who travel to the US and to Europe would recognize that there might be different standards at play when it comes to the sale of goods and services. Sometimes what they're trading in for consumption in the US and consumption in Europe might be at a higher standard to those that are being produced for regional markets, simply because the standards that should be in place in those receiving or importing countries are not what they should be. And it is taken for granted that, look, these are small countries, little banana republics, send them these. And as such, some of the times they even send goods with a very short shelf life. So if you can't move them off the shelf as a business person, you're stuck with them to try to call a sale, or you have to dump them at Connery. And we're saying that we should not have to put up with that. The legislation being proposed also means that the same standards that we would expect in first world countries North America, Europe, etc., we should expect to be applied right here in St. Kitts and Nevis, because the people of St. Kitts and Nevis are not second-class citizens when it comes to their purchasing power, their consumer knowledge, etc., and what they spend their money on, and have the right to demand quality. It also sends a strong message that the government of St. Kitts and Nevis, through the creation and maintenance of these standards, would not allow other countries to continue in any existing practices that might exist, such as substandard, soon-to-be expired goods, faulty goods, or poor quality goods, that they don't expect us to take them. As it is right now, between the existing legislation and the existing Consumer Affairs Act, which would have been passed in 2009, one would recognize that, for example, if a young single mother goes into Best for Less and tries to buy a bicycle, takes it home, her little 5-year-old gets on it and the wheel falls off, you take it back to Best for Less, they trade it, exchange it for another bicycle, and you take it back home again and the wheel falls off again. You take it back to Best for Less and they change it again. And at this point, the proprietor would be of the view that something might be wrong with the shipment. But guess what? He has no recourse overseas in terms of where he can go to get redress for that grievance. The most he can do at that point would be to simply give you a refund. Or if there's something else in the store that you thought that you needed, maybe you can get the value of those goods against the value of the item that you're not satisfied with and the store cannot reasonably give you a replacement for. So that too is another issue that we would like to address, and by extension, it is for that reason why this Parliament would have already had the first reading of the replacement bill for the consumer affairs legislation that is in place at the moment, so that when we would have finished all of these new bits of legislation, we would have been at a point of being safely on our way of providing for a national quality infrastructure and culture change when it comes to the provision of goods and services and the demand for such by and on behalf of the people of St. Kitts and Nevis. It also means that by having the new bill, we will now have the wherewithal in place to seek all the way up, if necessary, to the level of the WTO, which is our dispute settlement body, the address or redress of grievances when it comes to international trading disputes that we may have with international business partners, based on the fact that we would have already signed on to all of these international trading standards. Mr. Speaker, I should also note that one of the major advantages of the bill being debated today is the ability to develop technical regulations, which the present legislation does not give us. The existing legislation provides for general regulations that can be put in place in order to set basic standards as per Section 46 of that Act. We are keenly aware, and at times painfully aware, that the world that we are in now is not the same type of environment we were in 22 years ago. Counterfeiters have become craftier. Technology has aided them in having knockoffs and counterfeiting done and fraud committed, where it would almost take a man on a horseback with a magnifying glass to be able to see that something in front of you is not the real deal. And it is for that reason why we need the benefit of being able to have technical regulations that can be applied across different sectors, different spheres, etc., including but not limited to matters such as consumer protection, environmental protection, acceptable quality for goods produced for home use or for export, prevention of fraud, misleading advertising, misleading labeling, and also the preservation of health, welfare, and safety of the people of St. Kitts and Nevis. Of course, all of these regulations, which can be, according to the bill, which can be declared by the Minister on the advice of the Bureau, will be added over time to give effect to the provisions that we are passing here today, because it is not practical to expect that every single provision that we can come up with, every single standard, every single regulation will be covered by the 27 pages of the bill that we are looking at the moment. I should point out that the staff of the Bureau, led ably by Mr. Laplace, has already been proactive in advance of the passage of this particular replacement bill by having draft regulations with the aid of the Attorney General's chambers already put in place, ready for consultation to give effect to the new bill. And some of the early regulations that are already prepared include the general requirements for the labeling of goods entering the country, food labeling regulations, packaged or bottled water regulations, and we know that we have several water bottlers in this country, and conformity as it relates to tires. Why did we include this one on tires? And I have to say when I say this, that we are presiding over a set of coincidences here today, because we've just finished dealing with an amendment to the Road Traffic Amendment Bill. And at the same time, one of the reasons why we have chosen to come up with a draft regulation on conformity with tires is that based on the research done by the Bureau, we are convinced that a number of the road accidents that are being caused in this country could very well have to do with the standard of the tires that are on vehicles. What do I mean by that? We import tires from Japan, we import tires from Europe, we import them from China, we import them from the United States. And from those countries where we import tires that have temperate climates, meaning they have winter seasons, there are snow tires being sold. And at the end of the winter, they want to get rid of their snow tires. So guess what? Where do you think they're sending them? They're sending them to other jurisdictions that are unsuspecting. We buy these tires. They're not suitable for use in the Caribbean, where environmental and weather conditions are much different and road conditions are different, and you take it for granted that you're getting a good deal on a set of tires for your car, not recognizing that you could be digging your own grave by the investment in that type of tire. So one of the regulations that will be put in place very early with this legislation is the conformity when it comes to the importation of tires. So that is something to look out for. I should point out that on the issue of food labeling regulations, the Bureau is also working closely with the Pan American Health Organization to bring to the forefront of packaging labeling that has been long talked about in regional circles, international circles, including the WHO, including CARFA, in terms of ensuring that goods entering St. Kitts and Nevis or produced here that are considered food and beverage, once they are goods that have high levels of fats, salts, and sugars, that a regulation can be put in place to put that data on the front of the packaging. It doesn't mean that persons will not consume it, but at least those ingredients will be conspicuously placed on the product so that you see what decisions you're making about purchases and about the decisions in terms of what you're putting into your body. And why is that important? It is important because St. Kitts and Nevis has a very serious problem when it comes to non-communicable diseases, and every one of these types of foods, fatty foods, salty foods, sugary foods, would have a negative impact on someone's health. As it is right now, St. Kitts and Nevis has NCDs as the leading cause of death and disability. Some 83% of our deaths are due to non-communicable diseases. And by the placement of the packaging information right on the front of the label, it is hoped by global and regional and local agencies with interest in health that persons will become more educated on their food choices and make healthier decisions when it comes to diet and, by extension, lifestyle. So that is one other issue that we will be looking at in terms of food labeling. Other regulations which will be coming on stream would include the establishment of standard committees and technical regulation coordination unit within the Bureau, as well as the development of a code of practice to adapt good regulatory practices in certain enterprises, establishments, etc. There would also be identified as St. Kitts and Nevis technical barriers to trade focal point to facilitate a point of interface for the WTO. So at the local level, that person will be vested within the Bureau. If there is a trading issue for which there is a dispute, that can be addressed to the WTO via the Bureau of Standards. There are a number of other future regulations that would help to give effect to the legislation that would also call for the strengthening of partnerships between ministries, other than the Ministry of Trade under which the Bureau falls, such as tourism, agriculture, transport, to ensure that we do have the types of standards that are required to be in place to protect our people. Similar strengthening of partnerships are required with local importers, manufacturers, and with customs, because customs has to become a major player in terms of the partnership role with the goods and services and the standards we expect to ensure that these goods will have before they even are allowed to leave the gate of the port and be placed on a shelf somewhere. I would have noted in the front of this presentation that the Bureau of Standards Bill is omnibus in nature, and I would have explained what I meant by that. I would also go further to indicate that when omnibus pieces of legislation are placed before our government, it is an opportunity for us to look and to determine if that omnibus piece of legislation in its existing condition warrants being brought to Parliament as is, or should we do the extra step of doing the research, doing the local assessment or situation analysis to determine if there are portions of that bill that make sense or don't make sense in terms of entering the legislation, because we have to suit the legislation to our own situation here on the ground. And as such, the Ministry of International Trade and the management of the Bureau would have carefully examined the draft bill before bringing it to Parliament for that same reason. We would have sought the advice of the Attorney General's chambers. We would have undertaken our own research, secondary and primary, on the bill's implementation in other member states which have already passed it in their parliaments. We would have also looked for, asked and received advice from CARICOM in terms of COSCU, based in Barbados. We would have also sought and gained valuable information and advice from the German consulting firm that is currently assisting the Bureau of Standards with the development of our own national quality policy, the NPQ, that is mentioned in the interpretation section of the bill. For ease of reference, I should indicate that the NPQ, which is National Quality Policy, is meant to establish a national quality infrastructure in order to address conformity, metrology, standards, and accreditation functions of the Bureau. The consultancy on our NPQ is being executed by Meso Partner, Part G of Germany, which also has a regional office in Jamaica. And I am proud to announce that St. Kitts and Nevis also has a daughter of the soil who is working with that German consultancy, Meso Partners, in the person of Ms. Tamu Brown of St. Kitts. And she has been rather supportive in terms of the work that has gone into the drafting of that national quality policy. Mr. Speaker, based on the review and the research that we would have done, and the examination of best practices, and the expert advice we would have received from various agencies, the Ministry of International Trade and the Bureau of Standards would have taken the decision to remove from the omnibus bill that we would have received from CARICOM the provisions for a standards council at this time. And I repeat, we have taken the decision based on advice to remove from the CARICOM bill the provisions for a standards council at this time. The repetition was deliberate. There are several reasons for this. First, I must indicate for those of you who are familiar with the Parent Act, the existing one from 1999, that too made provisions for a standards council. And after 22 years, the Standards Council still has not been put in place, and there was a good reason for not putting it in place. Because what that calls for is basically the setup of a bureaucratic establishment within the Ministry of Trade, whereby you will be creating almost like another SCELEC, a quasi-governmental or statutory body, which will now take over the running of the Bureau. Regrettably, it is not the type of arrangement where you can put, like when you put somebody on a statutory board and you figure, oh, you put them there because they have something valuable to offer, or heaven forbid that they're a party supporter. When it comes to the Standards Council, the persons who sit on the council have to be vested with the knowledge, the skills, the expertise and the qualification to function in that capacity, especially when it comes to commercial standards, international trading standards, etc. Regrettably for us in St. Kitts and Nevis, we are not yet at that point to be able to say with confidence that we can go out and populate a Standards Council from among the skill sets that we have here in St. Kitts and Nevis. It is a step we are hopeful that we can get past so that one of these days we can come back and say that we now have the know-how, the wherewithal, the human capital by which we can then put in this Standards Council to function. But I am careful to add that in terms of the operations of that Standards Council, that council, if it was allowed to function, will be responsible for all of the staffing, all of the recruitment, the entire work program of the budgeting and financing. It would have cause to create financial statements, lay those statements in Parliament, etc., and also to handle the management of inspectors, etc. Now, basically, in terms of where we are right now, as I said earlier, these councillors would have to be chosen carefully. And in the research, as I indicated earlier, that was done, we would have looked at the member states where this bill had been passed. And every single one of them went ahead and passed the Standards Council as an insertion into the omnibus bill. But then guess what? Only 2 of those jurisdictions up to now have been able to implement or operationalize the Standards Council for the very reasons that I gave earlier, in terms of the difficulty in finding qualified people in country to be on that council. The only 2 CARICOM jurisdictions based on our research where that Standards Council has been effectively put in place have been Jamaica and Trinidad and Tobago. All of the others, even though they have passed it, that part of the legislation is still inoperable. Now, what do we do in lieu of the situation when it comes to not having a Standards Council? And the answer for us is simple. By virtue of the fact that the Ministry of International Trade and the Bureau of Standards had been proactive in terms of seeking out a consultancy, which, by the way, has been funded by the Caribbean Development Bank with the support of CROSCU, by going the extra step in having that national quality policy put in place, it has been drafted in such a way that it is going to make room for the assignment of staff appropriately, the decisions in terms of having the appropriate skill sets, specialized skill sets within the Bureau to make sure that the work gets done, to look at matters of the improvements in our laboratory, because the multipurpose laboratory is part of the Bureau, and also international accreditation at the same time. It would also allow us to effectively or more effectively handle matters of standardization, metrology, accreditation, conformity assessment, testing, certification, inspection, and market surveillance. The quality infrastructure provided by the policy will also enhance our national competitiveness and allow for greater economic diversification and present new opportunities for export market development, product development, and attraction of investment into the country. And by extension, that translates into improved foreign exchange earnings and the integration of our territory into the global value chain trading system. All of these benefits will be able to boost the confidence of our international trading partners and visitors alike who will access the goods and services that we have here. Mr. Speaker, as can be expected, the operationalization of this new act will have to be monitored and evaluated consistently by the indication of performance indicators within it, and basically have revisions as necessary in order to remain compliant with the provisions of the WTO, especially as it relates to technical barriers to trade and the agreement, that related agreement of the WTO. The ministry realizes that it will call for extra consultations, continuous consultation and partnership with importers, customs, excise, public education, consumer sensitization, among other matters. I would like to state, however, before I close off my explanation on the features of the bill, that one of the key features that has been preserved in the existing bill is that matter that has to do with secrecy when it comes to Clause 47. It was carefully put in the original act, and it is repeated here. And why is that necessary? Officers of the Bureau of Standards, in the course of their work, will from time to time have to do product testing. Those samples, when tested by the Bureau or with the support of other partner labs overseas, where our capacity cannot meet the demand for testing, would expose those officers of the Bureau to recipes, trade secrets, etc. So for example, let's say that there is cause based on consumer complaints to go into KFC and to do a testing of a sample batch of the product, which we know is very popular in St. Kitts, very popular as a global fast food brand. It then means that the staff of the Bureau will be able to determine the recipe that is used in the preparation of KFC. Same thing would happen if you had to go into a bottling plant where there was a license to bottle Coca-Cola, which too has an international trade secret locked under lock and key. It means that the staff of the Bureau will have to then go the extra step in securing and providing comfort to the retailer, the producer of that item that has a trade secret, which is part of its competitive advantage, to ensure that it is not shared with third parties. And by extension, there will be eventually a regulation dealing with that matter of secrecy and the need to have an oath of confidentiality signed by staff of the Bureau to ensure the safety of the trade secrets, trademarks, recipes, etc. that will be attached to the products that they are testing. So that is an important matter to look at. In general, Mr. Speaker, before I take my seat and allow for further inputs on the bill, I would like to use this opportunity to commend the ministry, the management of the Ministry of International Trade, the permanent secretary, Mrs. Jasmine Weeks, and Mr. Laplace in particular. Mr. Laplace has now grown the staff size, specialist size, up to 33 or so staff members to meet the demands of an evolving and modern Bureau of Standards. There's a transformation project that is currently on the way, paid for by the 11th European Development Fund, and when done, we would have the ability, under one roof, as the only jurisdiction in the OECS, to have metrology and microbiology taking place under one premises. And that is a remarkable achievement for which I now commend them. By extension, the Ministry of Agriculture, whose laboratory also adjoins the Bureau of Standards, has quite a bit of its technical improvements being done by similar consultants. And it is the long-term goal, as in the design of that whole complex, which would have an interconnected corridor, to allow St. Kitts and Nevis to have a rather modern laboratory complex for the Federation, with services being provided not just by the Bureau of Standards, but also by the Agriculture Laboratory that is its immediate neighbor on the same compound. So I wanted to note that. We have also been along the path quite far in terms of HACCP certification. And HACCP, as we know, refers to Hazard Analysis Critical Control Points, where you look at various stages of a process to determine and to ensure that the process is clean, especially when it comes to food production. And if there is contamination, you can go exactly to the point where the contamination took place and deal with it before it becomes a public hazard. And in the new year, by extension, because of the improvements at the Bureau, we are cleaning up our own backyard first by ensuring that we will have in place a situation whereby the abattoir and the fisheries division will be the two first agencies in government in early 2022 to become HACCP certified. And then we can move on to other private sector entities. I should indicate that in our partnership with manufacturing, some of the standards that they have in place surpass what we may have in place already. For example, firms like Cajola Cristado are already ISO 9001 certified, but are still required by law to work with the Bureau every time they are coming up for reaccreditation. And at the same time, we have a project being funded with the support of Caribbean, of CrossQ, etc., and I think Caribbean Export, to assist firms such as Cariboury in terms of HACCP certification, which they already have in place, I think, but also ISO certification. So, Mr. Speaker, there's a lot happening nationally in terms of where we would like to take our country when it comes to standards and quality, and the type of quality infrastructure we wish to have in place to create a new culture in St. Kitts and Nevis, where what we present to the public in terms of goods and services, processes and practices would be top-notch. Because as I indicated, St. Kitts and Nevis is a responsible member of the international community, and our people deserve no less than those citizens in first world countries. But it's going to take work. It is going to take legislative and regulatory infrastructure to be put in place to create those safeguards, and at the same time allow us the recourse to have redress of grievances on trade-related matters by accessing the WTO, of which we are a signatory. So essentially, I would like to close there and to indicate that there are several minor amendments that the omnibus bill would have, we would have noted, and these, if I'm not mistaken, would have been circulated by the clerk of the House before the start of my remarks. They constitute 2 pages and can eventually be dealt with when we come to the committee stage of the bill. With those words, Mr. Speaker, I wish the bill safe passage and look forward to its eventual implementation. May it please you, sir.